We're live. Good afternoon, everyone. Apologies to all those who are watching and in our waiting room to testify for the Ways and Means Bill hearing today. We're having technical challenges that we hope never happen again, but these things do happen sometimes. So again, I want to welcome everyone today. We have 12 bills to be heard, all on education. As I've said the other days, please be patient with us as we use this new technology. So thank you for your patience today. So no one has missed anything. Want to make sure that everyone in the waiting room, that your name is not your organization, isn't the word iPad, isn't your initials or anything else, but is actually your full name that you signed up with, so we know when to admit you into the hearing. And after your hearing, you will be removed from the Zoom, but you are free to watch on the YouTube station. And if you're coming back, just join again in the waiting room 1 or 2 bills before it's your turn again. So again, thank you all for your patience today. And we're going to start with Delegate Lopez, who's been with us this whole time. Delegate Lopez, House Bill 405. And this is, and judiciary is secondary on this.
Yes.
Thank you. Go ahead.
Thank you. Good afternoon, Madam Chair, members of the committee. Happy Inauguration Day. For the record, I'm Delegate Leslie Lopez, and I'm here to urge your support for HB 405. This bill authorizes a court to award related costs to the parent of a child with a disability who is the prevailing party in a certain special education proceeding. For background, since 1975 and the passage of Individuals with Disabilities Act, called IDEA, schools have been required to develop an individualized education plan, called an IEP, for students with disabilities. When parents disagree with their child's school about their IEP, they are entitled to judicial resolution through what is known colloquially as due process. At a due process hearing, parents can file civil complaints before an administrative law judge from the Office of Administrative Hearings. If these families are successful, their attorney fees can be reimbursed by the school. In 2005, the Supreme Court ruled in Schaefer versus West that parents must present admissible evidence about educational methodology, complex behavioral supports, medical issues, and other technical subjects to support their case. These qualified expert witnesses are the only ones who can present this type of testimony, and they can cost up to $1,500 a day, which increases the family's court costs by thousands of dollars. This creates an extensive burden on families of children with disabilities, many of whom are already financially strained. In fact, the Council of Parent Attorneys and Advocates says that nearly 2/3 of children with disabilities live in families with an annual income under $50,000. To sum it up, this bill aims to relieve the burdens on families with special needs of students by amending Maryland's law to explicitly state that successful plaintiffs are entitled to both attorney's fees and expert witness fees. The upcoming witnesses will testify that this change will allow all students with disabilities, regardless of income, to receive the best education possible. Thank you, and I urge your favorable report.
Thank you, Delegate Lopez. Are there any questions for Delegate Lopez? Delegate Ebersole.
Thank you, Madam Chair. This is really sort of not a question, but we'll let Delegate Lopez answer it. Do you know if this bill passed through subcommittee in Ways and Means last year and it was handed off to judiciary? And that may not be a matter of record, so I can help you with the answer if you're unsure.
I would love to be helped with that answer, as it is not nothing that I've seen suggests one way or another.
Right, because subcommittee votes are not a matter of record, but subcommittee did pass this over to judiciary last year, so it's of note that this committee already handed it to judiciary. They were unable to find time to act on it.
Thank you for that wonderful question, Delegate.
All right, thank you. Any other questions for Delegate Lopez? All right, seeing none, I have 5 people signed up. I'll start with Leslie Margolis. Good to see you this year. Happy New Year.
Thank you. Happy New Year to all of you. Thank you, Madam Chair and Vice Chair. As you know, my name is Leslie Margolis. I am a managing attorney with Disability Rights Maryland, and I'm here today on behalf of the Education Advocacy Coalition, which is comprised now of more than 30 organizations and individuals concerned with special education policy issues for children with disabilities throughout the state. So we are here again in support of House Bill 405, which is at the heart of it, a bill about access and equity. The federal special education law and state laws guarantee families the right to seek dispute resolution if they are concerned about the education of their children with disabilities. And it's very difficult for families to find lawyers. It is particularly difficult for families of low and moderate income, if they even find an attorney, to find an expert. The school systems have ready-made experts in their staff. They can pull them into a due process hearing, but families don't have that luxury. And currently under federal law, and in state regulation, if families win a hearing, they can recoup the cost of their attorneys, but they are not able to recoup the cost of their experts. And that has really proven to be a barrier for many families to access their ability even to ask for a due process hearing. So what this bill would do is enable families to recoup the cost of their experts if they prevail at a due process hearing, only if they prevail at a due process hearing. So we know that this committee has passed this in past years. We hope that you will continue to do that, and that this year maybe families will have the opportunity, regardless of their income, to access the rights that they're guaranteed by federal law. Thank you very much.
All right, thank you, Ms. Margolis. Next, we have on the list Rosemary Kitzinger. Ms. Kitzinger, are you here?
So she just texted me that she was in the waiting room and was hoping to be let in. So I know she's trying to access this, and
there's no one in the waiting room with that name. So if she can change her name appropriately, I'll invite the next person. And then if you can have
I'll text her.
Fix her name. Thank you.
Sure.
Maureen Van Stone, I know that I saw you already.
Yes, good afternoon, Madam Chair and committee members. Thank you for this opportunity, and thank you, Delegate Lopez, for sponsoring the bill. My name is Maureen Van Stone, and I am the director of the Maryland Center for Developmental Disabilities, which is Maryland's University Center for Excellence in Developmental Disabilities. And I'm the founding director of Project HEAL, which stands for Health, Education, Advocacy, and Law at Kennedy Krieger Institute. Project HEAL is a comprehensive medical legal partnership that provides advocacy and civil legal services to children with disabilities across the state of Maryland. It is my pleasure to testify in strong support of House Bill 405, which would allow parents to recover attorney's fees and expert witness costs if they are the prevailing party in a special education due process hearing or a court proceeding. Project HEAL attorneys represent children with disabilities and children with complex medical histories who are at high risk for adverse outcomes if within the school setting, if they are not provided with the critically needed services and supports that they require. Project HEAL attorneys work to ensure that hundreds of Maryland children with disabilities have an appropriate educational program and placement. We work with low and moderate income families, which gives us a unique perspective into the necessity of House Bill 405. All too often, families of low and moderate income families are unable to meaningfully participate in the special education dispute resolution process because of their financial limitations. House Bill 405 will seek to close that gap and enable greater equity and access for families of any means. Since 2014, Project HEAL attorneys have analyzed and shared the Maryland due process hearing data in special education disputes, and no unrepresented parent has ever prevailed at a due process hearing. Even if parents are able to find an attorney to represent them, they will need experts to present their case to the administrative law judge within the Office of Administrative Hearings. School systems commonly present experts at these hearings, and so in order to present a case that is compelling, our parents must do the same. At present, federal special education law permits parents who prevail at the hearing to recover attorney's fees from a court. However, as stated previously, Maryland state education law contains no similar provision. Additionally, parents are not able to recover the cost of their experts, which often totals thousands of dollars for any hearing. Ultimately, because of the financial burden associated with due process hearings, many families are not able to exercise their rights that they are afforded because they cannot pay for their experts. This effectively strips rights from low and moderate income parents, while other families, those who have financial means, are able to exercise their rights. This is fundamentally inequitable. House Bill 405 would incorporate into Maryland law the attorney's fees provision currently covered by IDA. Additionally, the reimbursement of experts would make this due process protections afforded to families less illusory. The passage of House Bill 405 will increase access to special education due process resolution for all families regardless of their financial circumstances. For these reasons,
Thank
Project
you.
HEAL strongly supports the passage. Thank you for your consideration of this testimony.
Thank you, Ms. Van Stone. I don't see Rosemary Kitzinger still. If she comes in after the opponents, we will let her speak. But questions for the two proponents, and I will start with a question for either one of you, Ms. Margolis or Ms. Van Stone. This idea of the attorney's fees, I believe the argument is that people don't go this step because they're afraid of the costs. So how much could an attorney cost in these cases and the build up to the cases?
Well, both of us practice in the nonprofit arena. Disability Rights Maryland doesn't charge, but our understanding, from folks who contact us who have been in touch with private attorneys is that to take a case from the beginning to the end could cost $40,000 or $50,000. It's really quite prohibitive for many families. And then when you add to that the cost of experts, which can run into the thousands, depending on how many experts you may need, it's really prohibitive. And
Okay, thank you.
And because the law allows this as an option for families, what it does is end up foreclosing families from exercising their rights. I know that Rosemary Kitzinger is having difficulties apparently, but with a name she may have signed in on an MGA and a name on her Zoom account, so she seems to not be able to get in.
Okay, thank you. We do have another question, Delegate Polakovich-Carr.
Thank you, Madam Chair. And this could be for either of the witnesses. So in written testimony from one of the opponents, they note that under state regulation in Comar, there already is an ability for families that prevail to recoup their attorney's fees. Could perhaps one of you just talk to why this would be needed under state law and how that's working out right now in terms of the current regulations and if that's not sufficient?
So I can address that. In the regulations right now, so federal law allows the recovery of attorney's fees. It does not permit the recovery of, or doesn't mention the recovery of expert costs. State regulation, Comar, incorporates the provision allowing the recovery of attorney's fees, but also does not address expert costs. So in order to address the expert costs, which is really attached to attorney's fees, the vehicle for addressing expert costs was to put the attorney's fees provision into state law as well, because it's not going to happen through regulation only. So the vehicle to attach expert costs was to attorney's fees, and that's the logistical reason for asking for the attorney's fees and expert costs. We're really concerned. We know federal law allows the recovery of attorney's fees to prevailing parties. We really wanted to get at we're hoping to get at the issue of expert costs for families because that's really a barrier for many families.
Thank you.
Thank you both very much. If there's no other questions, we do have two people speaking in opposition. First, invite Mr. Willems to testify.
Madam Chair, members of the committee, John Willems, representing the Maryland Association of Boards of Education. You have MABE's written testimony, and I would suggest that much of the framing of our argument against this bill has been made by the proponents relative to the Ms. Margoli's recent clarification that the federal law already provides parents the right to recoup attorney's fees. We do not mean to be snarky in any way when we say we would support this bill with an amendment to have it govern attorney's fees, but not the expert witness fees. That language tracks the IDEA, the Individuals with Disabilities Education Act, and state regulations. But as Ms. Margolis pointed out, the expert witness fee provision does not. And it is clearly a minority view among the 50 states to provide the reimbursement of expert witness fees. Only a handful of states do so. And we do not believe that Maryland should go down this route, primarily because of what this committee has heard many times before. The overall framework of IDEA and Maryland's approach to special education services is intended to be collaborative, non-litigious, and to work things out before going to the mat, if you will, through the due process proceedings. But if that route is taken, attorney's fees are available to be awarded by the judge. And expert witness fees are somewhat in the eye of the beholder relative to the value of what can be very expensive and maybe less helpful additions to the collaborative process of parents in the school system working out what services are available for their student, and would certainly add considerably to the cost burden of resolving special education disputes. Would just note that local school systems are painfully aware of the struggles of our students receiving special education services and their families through COVID and the school shutdowns. We want to get back to living up to the letter of the law of our IEPs and 504 plans, and providing all the strictures of related services that are called for in those plans. Everyone is striving to do their best, but it has been virtually impossible to live up to the letter of each and every one of those agreements. We do not feel that this bill would help in any way in our returning to doing so. And for the reasons provided in our written testimony, which describes some of the recent Supreme Court cases, 2006 through 2017, and the most recent Supreme Court case does hold school systems' feet to the fire to ensure that we are developing plans intended to make progress on behalf of the student, which seems rather obvious. And it's a little sad the Supreme Court had to say so, but we're
John, can you, one sentence, that's it, wrap up?
We urge
Time's
an
up.
unfavorable report on this bill.
Thank you, John. Mr. Tolley? Nope, you got to unmute. There
Is
you
that
go.
better? I apologize, Madam Chair. Thank you very much for this opportunity. My name is George Tolley. I'm Legislative Chair for the Maryland Association for Justice, often described as the trial lawyers here in the state of Maryland. Our position on this bill is very narrow. First, I want to acknowledge Delegate Lutke, and also on the Senate side, Senator Zucker, who we met with last year in connection with this proposal, and we tried to find a way to resolve it or amend it in a way that would keep us off this bill, because frankly, we're not education experts. The current law, as has been already said, allows for the recovery of attorney's fees and fee shifting. That's federal law. Nothing we do here in the state is going to change that. Maryland state law has adopted those federal standards wholly and entirely, and the COMAR regulations permit it. What this bill does that is concerning to us is allow the shifting of expert witness fees. The shifting of litigation costs in general is antithetical to what's known as the American rule for civil litigation. It's in contrast to the British rule. In Great Britain, fees and costs are routinely assigned to the non-prevailing party. And as a consequence of that, what you see system-wide is a dramatic reduction in access to the courts and a dramatic reduction in access to justice. It would be devastating in America to see expert witness fees routinely assigned to the non-prevailing party. And while I understand that, everyone's hearts are in the right place, and we want to try to make access to IDEA dispute resolution more available to everyone, there are other ways to do it that don't do damage to the American rule and don't require shifting expert witness fees. And we'd be happy to explore some of those. We'd be happy to provide whatever input we can, but the issue really is this is the beginning or maybe a continuation, because I'm sure somebody's going to say, well, it's already done in some other kind of litigation. And that's the slippery slope. If you've already done it once, it makes it easier to do it again, and then to do it again, and then to do it again. And in the end, you end up with civil justice that's just not as accessible as we want or need it to be. And with that, we urge an unfavorable report on the bill, or perhaps again, as maybe favorable with that one line, page 6, line 11, stricken out about expert witness fees. Thank you very much for your time.
Thank you, Mr. Tully. We do have at least 2 questions for you both. We'll start with Delegate Lukey.
Thank you, Madam Chair. Let me start quickly with John. I understand MABE's position here because this would put potentially extra cost on the school systems, but your defense of it seemed to suggest that, is it MABE's position that IDEA is a perfect law and we should make no changes in it whatsoever?
No, and good afternoon, Delegate.
Good afternoon.
We do not believe it's a perfect law, and we are very active at the federal level through the routine process, which has now been quite a while since it's been reauthorized at the federal level. And so MABE tends to represent, I would say, the more liberal or progressive wing of state associations of boards of education, given that some of the more progressive initiatives to reform IDEA actually come from some Maryland organizations, and some people on, at the hearing today are involved in that. And so we feel that our state regulations and state laws already go significantly beyond the federal law. And so the parental consent legislation, which we did not support in its entirety, is introduced, but as amended, I think ended up in a very reasonable place. That's a prime example of providing parents a greater role and more rights in the process than the federal law provides.
Do you know, and I don't know if you know off the top of your head, how many cases are we talking about here where a due process case is filed and the parent actually ends up the prevailing party in Maryland?
I do not have those numbers.
I mean, is it in the range of fewer than a dozen cases a year?
Can I answer that question?
Only that question.
Okay,
Just
sure.
that number.
So each year we have around an average of 18 cases. The most we've had since 2014 is 23. The least is 16.
That's
It's
total.
Thank you, Ms.
Total cases.
Thank you, Ms. Van
So that's
Stone.
total cases, not necessarily cases where the parents prevail, which happens relatively rarely. Can I ask, George, last year, and I appreciate MAJ because I feel like a lot of times you guys are the advocates for the underdog, the little guy, right? But here MAJ is in a position where you're not, right? You're the advocate for the big dog. And the bill last year passed Ways and Means, I believe, unanimously, ended up in Judiciary, and the Judiciary Committee held it up largely, frankly, because of MAJ's concerns. But your concern fundamentally is that you believe that any challenge to the American rule, even in this case where the litigants are probably the most sympathetic litigants you can find, will potentially undermine the entire system of civil justice in the U.S.?
Oh, so first of all, thank you very much. I appreciate the kind words. That's one way to put it, I suppose. Really, what we don't want to see, and you see this all the time. There's a sympathetic party, and the legislation is passed to favor that party, and then it in the end comes back, and there are negative consequences. And immunity legislation is the same thing. We've been in committees focused on education where the school systems want to help children with diabetes, another very sympathetic group. But to give immunity for anybody who helps a child with diabetes, we will oppose that. We're not, and let me be clear, I'm not here on behalf of the Board of Education. I'm not here on behalf of any big guns. I'm here on behalf of the trial lawyers who have a vested interest in safeguarding civil justice. it just so happens in this instance that it sounds like our request and MABE's request are the same, and that is that the expert witness fees element of this bill goes just one step too far. If it's viewed, and I don't want to take up too much time or go too far beyond the scope of what you asked me, Delegate Lutke, so if I do, please just let me know. If it's viewed as a good thing to have more litigation in the IDEA space, the state could set up a nonprofit that fund it through state money, and parents can apply for money to pay for experts. That is a way that doesn't involve fee shifting, but it involves the state pursuing a public good with public money. There are other ways to solve this problem.
Kind of like a civil Gideon, but for expert witness fees for these cases.
There's a lot of talk about civil Gideon. There is certainly that.
All right.
And we don't need to go there today, but that's certainly a possibility.
All right, we have the next question, Delegate Hornberger.
Thank you, Madam Chair. Just a quick question for the opponents. I understand that this can get very expensive. We recently had a case in Cecil that went into the hundred thousands of dollars for a settlement, and understand the apprehension. My question for you is, would you support a cap, for example, on expert witness fees to kind of safeguard this from becoming a runaway issue where you have to pay out of the fund?
I suppose I'll go first. And thank you for the question. I'm not sure is the only answer I really can give. I don't know enough about the details of it, and it would require a little bit more consultation with folks who do know to be able to give you a more definitive answer. It would depend on the nature of whatever cap might be.
Okay.
Candidly, my suspicion would be that if it involves the shifting of fees, we would respectfully request that not be included in the law.
John?
Excuse me. I think the concern would be that the cap would have to be significant enough to actually, compensate for what could be expensive fees, and could end up being more of the norm than a cap that was only, rarely achieved. In other words, the plaintiffs would have some incentive to reach that cap if they knew they could be reimbursed for those fees. So I'm not sure how you could get at a cap setting.
Well, right now, the cap is effectively zero. So it bars someone from actually even seeking out an expert to come in and weigh in.
Well, not every expert is particularly that expensive. And so, you can be talking several $1,000s in addition to what can be tens of thousands of dollars in litigation costs. And so we're not envisioning the expert witness fees doubling or tripling the overall, settlement, from the school system. But it is that additional benefit, if you will, to going the litigious route as opposed to working it out at the collaborative table that is of concern to us. It's not that the expert witness fees are, I think, ever going to swamp the attorney's fee by scale.
Okay, and then the last question, Madam Chair, if I may, do we have an aggregate number per year on what these settlements look like for these cases where the parent prevails in terms of legal fees?
If you don't have it, John or any of the proponents, can you send out that along?
Okay. Thank you, Madam Chair.
Thank you, Delegate Hornberger. Our last proponent did sign up, so we are going out of order since she got here. Ms. Rosemary Kitzinger, if your chance to testify.
Yes, I would love the chance. Thank you. I'm sorry, technical difficulty today, and bear with me because I will just admit to you, after watching the inauguration all morning, I'm quite an emotional mess as a female in this country and quite proud today. So bear with me. I am Rosemary Kinstiger. I am a mother of 4. I live in Carroll County resident. 2 of my children do have disabilities. I have had the unfortunate displeasure of having to go through the due process more than one time in this county. The first case was several years ago when my oldest daughter, Marissa, who has autism, was not able to be served appropriately in her public high school. And we had watched her mental health greatly deteriorate due to her increased anxiety. So my husband and I had to meet with an attorney, and after consulting with them, we left feeling very defeated because we had no idea what the cost of due process could potentially be. But we were looking at a very hefty retainer for the attorney, which was explained to us potentially if we prevail, and the chances are very small in Maryland, I think less than 10% of parents actually prevail in due process, that we could potentially get some money reimbursed if we prevail, but not on expert fees. And we would be looking at potentially $1,500 to $4,000 or $5,000 in expert fees, depending on how many we needed to testify. We left that meeting very defeated. We went home, we felt defeated all night. We woke up the next morning and we started our plan. We held a bingo at our local fire hall to raise funds. We had bake sales, we had raffles, we had the community get involved to help us accomplish this. We online fundraised, we sold personal items just to raise the money to prepare for due process, to be able to hire the attorney and pay for the experts. Luckily, my daughter was able to get her appropriate education elsewhere. And fast forward several years later, in 2016, my youngest son, at the time, we didn't know he was dyslexic. We do know that now. But in the IEP process, there was a disagreement over assessments, and the county chose to file due process against my 9-year-old son. In the 3-day due process, again, I was faced with attorney fees and expert fees. And what I noticed during that time, looking around the room, that there was no less than 6 to 8 staff members in addition to the board attorney every single day of that due process. And I'm pretty sure they didn't bake sale to raise funds for that staff. What I find about this bill is it is a small step in some equality and equity in the system. Our procedural safeguards are good ones, but they are only as good as accessible. We have to make this accessible to parents.
Ms. Kitzinger, your time is up.
Thank you.
Would you like us to move favorably on this bill?
I would like you to move favorably. Yes, thank you.
All right, thank you. Any questions for Ms. Kitzinger? All right, thank you, Ms. Kitzinger. Thank you to all who testified on that bill. Thank you, Delegate Lopez. We're now finished with a hearing on House Bill 405. Delegate Anderton's been waiting patiently with us. House Bill 72. Delegate Anderton, very good to see you.
Yes, ma'am, Madam Chair. Good to see you too. Committee members, family, how's everybody doing? I don't know what this background is. I think my staff has had some fun with me today. I look like one of those commercials you saw like back in the 1980s, I guess. And you can have this too, you know. So real quick, I know you have a busy day. House Bill 72 is a refile of a bill that we submitted last year that this committee amended into a statewide bill that passed the House unanimously and made it over to the Senate and got coronaed like everything else. I wish I had a flashy name for the bill, but instead it is County Boards of Education, Student Transportation Vehicles. It deals with dignified transportation of students who otherwise have been forced to take taxi cabs home, transient students, special needs students, students in foster care, students without access to school buses. And so, you know, this is a waiver system has been in place that local school boards, as you know, would have to ask for one from the state. And sometimes they're approved, sometimes they're denied. And so due to that, this was requested from Wycomico County. And then again, the committee saw fit to turn it to a statewide bill to offer dignified transportation options to all our students. And so this bill passed unanimously last year. It is unchanged. It is in the exact form that you placed it. And so I'm asking for a favorable report and to let it move back over to the Senate once again.
Thank you, Delegate Anderton. Are there any questions for the good delegate? If not, thank you, Delegate. Good to see you.
Thank you. You too. Absolutely.
And we're going to move on to our next two bills. We have Delegate Wilson, Delegate CT Wilson, and we'll start with House Bill 342. Good to see you, Delegate.
Good to see you, Madam Chair. Colleagues, Madam Chair, Delegate Wilson here presenting House Bill 342. Some of you may remember this bill from last year. It was House Bill 1005. It did go through and died in the committee without a vote because we had it early in the session. So I'm here today to re-present this bill that addresses the unfortunate increasing problem of sexual behavior by our younger students. And some of you may know, as we spoke last year, this was brought to my attention because a year and a half ago, there was a problem with a teen-year-old that was charged with a fourth-degree sex offense. But the background behind that was a little even more confusing and painful, was that 3 fourth-grade girls basically reported that 3 fourth-grade boys took one of those girls, tied her to a slide, simulated raping her with clothes on, and yelled they were going to blank her very hard. Now, the problem is we understand now that the response of the teachers and the principal was to call law enforcement in and basically bring individuals who maybe even not properly trained to respond to these kinds of investigations in the sensitivity of this case. And they talked to the children. The parents were never notified. They found out from their own children. In fact, the 3 boys and the girl that they tied up all had to ride the bus home together. The parents found out again later. And when they tried to get any information out of the school administrators and law enforcement, it was explained away because why? It was an active investigation. And that's a problem. Because, we have no standard for notification of parents in cases of problematic sexual behavior. There's no one policy, and there are many inconsistent or non-existent policies across the jurisdictions of the state. This would require parents of the children with the problematic sexual behavior, as well as the victims, to be notified immediately of the incident. Now, we live in a culture now where kids are being basically bombarded by sexual activity as early as 6 and 7 years old. They have access to pornography via their phone. And regrettably, the problem of the children's sexuality and sexually acting out on what they see is just going to get bigger because we can't really get a handle on that. We need some systemic ways of reforming that. Parents cannot help their children if they're not notified. And they should know when they drop their kids off at school that they would be notified for any situation such as this. This would just require that they're immediately notified and hopefully put themselves in a position to have developmentally appropriate responses and avoid the re-victimization, because many times when you have a young individual who may be victimized, policeman's interrogation doesn't really help the situation. And of course, there are other bills dealing with interrogation of juveniles, but I'm not sure where those bills are going. So I wanted to make sure that we have something to protect both the victim and deal with the aggressor, because many times they themselves have either been victimized or they just witnessed too much as young kids. I do have an amendment that I put in. I don't know if you've received it yet, because there was some concern that from the school administrators, if they thought that basically the parents or the caregiver of these children may have something to do with this or suspect that they may be sexually abusing their children, we needed an alternative. And that amendment just says that they must report it to CPS rather than reporting it to the parent directly. For these reasons, I urge a favorable report on House Bill 342.
Thank you, Delegate Wilson. Thank you for your continued advocacy on this issue. Any questions for Delegate Wilson? Yes, Delegate Rose.
Just to clarify, and thank you for bringing this bill again, Delegate Wilson. Will the parents and CPS be notified or just CPS?
If it would be the parents, but it doesn't require, if they believe that the parents are suspected of child abuse, it doesn't, the amendment would not require them to notify the parents in those cases. Because what you don't want is a child to quote unquote, to get in trouble at school and then go home and be victimized, even if they were the aggressor. So on those cases, they will only have to report it to CPS with the rationale that they believe that the parents are either involved or somehow abusing, or caregivers are abusing these children.
Okay, so that would be the call of the school administrators.
Yes, and obviously they would have to explain themselves, but because the rationale, the goal and the policy behind it is to notify our parents. But in those rare cases where I believe the parents are involved, we'd like them, to avoid that.
Okay, thank you.
Thank you, Delegate. Any other questions for Delegate Wilson? All right, thank you, Delegate. Two people here to testify today. I'm going to invite Jennifer Gross and then Claudia Remington to speak. Ms. Gross.
Thank you, members of the committee, and thank you, Delegate Wilson, for once again being a champion for our children in Maryland. I'm Jennifer Gross. I'm a licensed clinical social worker and a certified sex offender treatment provider. I've worked in the field of child sexual abuse for the past 27 years. And one thing that's become very clear in the past several years to adults in Maryland, from our schools, therapist office, child advocacy centers, CPS, police, sexual assault nurse examiners, and we as parents, we're all seeing a huge increase in youth with problematic sexual behaviors. This trend is also being seen nationwide, with experts worrying, especially in this year of kids being out of school during COVID and the massive increase in isolation and increased screen time that they're having, that there's going to be even larger increases in the already high number of our children experiencing this issue. This is perplexing and alarming us as adults, as we're not sure what is driving this tremendous increase. Is it the over accessibility of violent pornography that even our youngest kids are watching? Is it the dramatic increase in even small children being on social media constantly? We're not sure. As more and more data and research is gathered and conducted, one thing is sure: all parents must be aware of this issue, educating themselves and their children regarding appropriate boundaries and behaviors. We have to be able to guide our children in topics regarding consent, pornography, and relationships. While all parents must have this knowledge, for some parents it's critical. Parents whose kids have either acted out sexually in a problematic way, or parents whose kids have been acted upon are in urgent need of this information. The research on why kids are acting out more is not yet clear. The research on children who act out sexually and children who are victimized is very, very, very clear. For both sets of kids, early intervention is critical and highly effective. For kids acting out, they can learn to control their behaviors and end them, preventing more future acting out. For victims, they can learn that the actions were not their fault, learn boundaries and other skills, and thus prevent the often long-term devastation that childhood sexual abuse often causes. Everyone agrees on this. Parents cannot, however, act upon what they don't know. Far too often, when kids with sexual behavior problems act out in schools, the parents of the children are not told. Parents cannot help their children unless they know there is a problem. It's as simple as that. This bill is simple, basic, and powerful. Parents must be notified within 24 hours of schools becoming aware of problematic sexual behaviors. It's easy. Without this information, parents cannot act to help their children, and the problems will get worse when they could have been corrected more quickly. For those reasons, I urge a favorable report on this bill. Thank you very much.
Thank you. Ms. Remington?
Chair Kaiser and distinguished members of the committee. Thank you for the opportunity to speak in support of HB 3042 with amendments. My name is Claudia Remington. I'm the Executive Director of the Maryland State Council on Child Abuse and Neglect, or SCAN. SCAN's a multidisciplinary advisory body required by Maryland family law, and to make recommendations to the Governor and General Assembly on prevention, detection, prosecution, and treatment of child abuse and neglect. I'm just going to make a couple points. Our testimony reiterates a lot of the points that Delegate Wilson and Ms. Gross pointed out, but I think it's really important to understand that Maryland, like most other states, doesn't have a consistent system and policies to effectively respond to the problem. And school administrators, child protective services, law enforcement are often the first responders, and yet they don't necessarily have statewide policies, training, or understanding of best how to manage these children with problematic sexual behavior and the victims of that behavior. Child protective services is not required to respond to cases of problematic sexual behavior unless the children involved are living in the same household or sexual abuse or neglect is suspected by of the caregiver, the parent or the caregiver. So for these reasons, we should have work towards a more comprehensive and coordinated system. Our CACs are in a good place to do that, but they don't are not funded to do that across the state at this point. So it would be important that this is a first step to make sure that parents have the information that they're to be able to protect their children and respond in an appropriate way. For these reasons, the council urges a favorable report on HB 342 with the suggested amendment. Thank you.
Thank you, Ms. Remington. Are there any questions for either of these ladies who just testified? All right, seeing no questions, thank you all very much. Thank you for joining us today at our hearing. We're done with the hearing on House Bill 342. Delegate Wilson, House Bill 373.
Thank you, Chair Kaiser, distinguished members and colleagues. I'm here to introduce House Bill 373, Education, Child Abuse, and Sexual Misconduct Prevention, the hiring of emergent employees. This bill was also introduced last year, House Bill 1008. It received a favorable report and with some agreed upon amendments in the committee and passed this House, but unfortunately did not receive a hearing in the Senate due to the COVID. Just a brief background, as you guys may be aware, 2019, I brought a bill that we passed called Sesame, which is the School Employee Sexual Abuse, Misconduct, and Exploitation Act. It passed unanimously in both houses and established rules for vetting our school employees and keeping personnel that are credibly accused of sexual abuse or sexual misconduct out of our schools. However, I was approached by my own superintendent in Charles County requesting that we put something called a provisional hiring section or clause introduced into this Sesame bill. And as I pointed out before, that was actually in the original bill, but MSEA opposed it to the point it was struck, and we went on with Sesame as it was passed. So this current bill is identical to the bill we passed last year, and these are agreed upon amendments from MSEA, MAID, Superintendent's Association, Bus Drivers Union, local education agencies, the State Council on Children Abused and Neglected, State Council on Child Abuse and Neglect, and the advocates of Sesame. There's an effort, this is done just in an effort to identify and administrate implementation issues while ensuring child safety. Basically, we had some issues with hiring. It was slowing it down, and we put these amendments together to expedite so we can keep some of these good teachers and employees. We don't want to scare them away from Maryland, but we do want to properly vet them. And what it basically does, just briefly go over, it defines what an emergent employee is, and ensures all employees are listed. All employers are listed. It goes back 10 years. It allows for a hiring period of 60 days while we do the background and research. It allows individuals in schools, public schools and non-public schools to not only share that history, but also rely on their own research. So basically, if you've applied to several schools, one school does the research and you move, you can rely on that prior school, their vetting process. And for schools and non-public schools, I know that there's an amendment, it's a technical amendment to ensure that non-public schools is included in each and every facet of this. I've negotiated these changes last year. These are all the changes from 2020. We're trying to do it in a way to ease the administrative process without compromising the goal, which is student safety. At the end of the day, we reopened Sesame to ensure that these issues would be taken care of, but it would be paramount for our children's safety. I understand that there may be some amendments. I think the school bus drivers are trying to basically have an amendment that would allow them to rely on other companies' vetting process. Not really for that. We've already negotiated with the bus drivers to allow them to be hired as long as there's somebody either there with them or there's video, audio recording. I don't believe having companies whose goal it is to make money, not protect our children. We don't need to rely on them the same way we rely on our schools and our school systems. So I believe as this bill has been presented, it's complete. Hopefully it's easy administrative process and allows us to continue to protect our children. I would ask for a favorable report for House Bill 373.
Thank you, Delegate Wilson. Appreciate you coming back on this bill. Members, any questions on this bill? All right, thank you. Seeing none, we're done with the hearing on House Bill 373. We're moving on to Delegate Ken Kerr's bill, House Bill 370.
Thank you, Madam Chair.
Welcome, Delegate Kerr. I will be handing this off to the Vice Chair in a moment, but you can get started, and there are 5 witnesses here.
Thank you, Madam Chair. Members of the committee, I'm Delegate Ken Kerr presenting House Bill 370 Seizure Action Plans. You may recall this bill was introduced last year, but was not acted upon before our early adjournment. This bill is about keeping children safe in our schools, specifically children with epilepsy, as well as children who have their first seizure while at school, and the teachers and children in attendance when the seizure occurs. Epilepsy refers to more than 20 different types of seizure activity. 1 in 10 people worldwide will have a seizure in their lifetime. Epilepsy, or recurring seizures, develops in 1 in 26 people in their lifetime. Seizures and epilepsy are not the same. A seizure is an event. Epilepsy is the disease involving recurring unprovoked seizures. Simply put, epilepsy is diagnosed after 2 or more unprovoked seizures. The cause in 70% of all cases of epilepsy is unknown. 25% of new cases of epilepsy occur in children 14 years and younger. This makes it highly likely that a child's first unprovoked seizure will take place at school. And population-based estimates are that every year, 25,000 to 40,000 children in the United States experience a first unprovoked seizure. Johns Hopkins Medical School and the Center for Disease Control estimate that 6 in 10 students in every school have epilepsy. The first 2 points in the Center for Disease Control publication called Managing Epilepsy at School are: 1, educating a school nurse, teachers, staff, and students about epilepsy and its treatment, seizure first aid, and possible stigma associated with epilepsy. And 2, following a seizure action plan. And this is exactly what this bill attempts to do. By their very nature, seizures are unexpected. A seizure in a school child is frightening for all involved, children and teachers alike, and an untrained teacher may panic, further traumatizing the children, calling a 911 dispatch for an unnecessary, unneeded ambulance, and further frightening the child having the seizure. The greatest, most effective antidote to fear is knowledge. And that's what this bill does. It requires that every public school will have at least 2 adults trained in seizure management. This legislation has passed in 5 states, and 18 states are currently considering bills similar to HB 370. To our south, similar seizure-safe school legislation in Virginia just unanimously passed the Senate subcommittee and is moving forward with no opposition. To our north, Pennsylvania is considering similar legislation this year. Now, there's a forthcoming amendment that resulted with our conversations with the Maryland Association for School Health Nurses and the Maryland Nursing Association. At last session's hearing, there was no opposition. This year, we see that the Maryland Association of Boards of Education has opposed. We're a little surprised to see that opposition now. In his opposition letter, Mr. Willems points out that they have in place programs to address sickle cell disease and diabetes, but they lump epilepsy under the condition of other health conditions.
There's Robin or somebody.
You'll hear from my panel that epilepsy is just not another health condition. The National Epilepsy Foundation responded to MABE's opposition by saying, quote, "People should know how to respond to seizures appropriately and effectively, and that is just not the case right now." End quote. Placing seizures in the other category won't accomplish this. We are and have always been open to dialogue with MABE to address their concerns. And we hope that this year you'll find a favorable report for House Bill 370. And now I'd like for you to hear from my panel. Thank you.
Thank you, Delegate. I think we're going to take questions first for you, Delegate, and then we're going to go to your panel. Is that all right?
Oh, thank you.
Great. Delegate Guyton, first question.
Thank you so much, Mr. Chair, and thank you, Delegate Kerr, for bringing this bill to us. I've heard a lot about this bill. I know there are a lot of folks advocating for it, and I think it's also very important. I do have a question about the MABE opposition, and it doesn't, I guess my question is, there are a lot of disabilities that are actually lumped under other health impaired. It does not in any way indicate that they are lesser disabilities or less complex or less dangerous than other disabilities. So that argument to me makes absolutely no sense. It doesn't, it also, well, there is a question here, I'm sorry. So if necessary then, I suppose my question, I don't believe it is, but is it necessary then for the disability, whether it's seizure or anything else, to fall under its own categorization in the IEP schedule to get these sort of special services? I've never heard of that before.
Well, they specifically have programs in place to address sickle cell disease and diabetes. And the prevalence of diabetes and the prevalence of epilepsy in the United States are identical. And 1 in 10 people will experience sickle cell disease, but 3 in 10 will experience a seizure. So this should be at the very least considered equivalent to those diseases that they're
Sure. I guess hopefully one of your panelists can maybe address, because I'm used to looking at IEPs and 504s, so could address that question of, does it matter if it's categorized under other health impaired? I don't believe it should, but if someone can answer that, that'd be great. And I'll yield. Thanks. Thank you, Mr. Chair.
Hi, I'm Diana Bremen. I'm a teacher in Will County.
Diana, not yet.
Oh, I wanted to answer her question. I'm sorry.
Yeah, we're going to wait till your testimony comes up before we send. So just wait 1 second. So we're going to go to the next question to Delegate Ebersol.
Thank you very much, Mr. Chair. So I see that you have a training element indicated here, an annual training element. There are a couple of questions. Do you have any idea what kind of length of time we think that this would take? Because it looks like you want all staff to be trained annually in this. And I read down quickly, and it may be there, and I apologize if it is. Who's going to design this training? I saw the elements of it, but where's the design of it going to come from?
This will probably come up from my panel, but I'll just tell you briefly.
Okay, well, then I'll wait. I'll hold the question till then if you'd like.
Perfect. Okay, cool. Any other questions for the sponsor of the bill? Seeing none, thank you, Delegate Kerr. We're going to go to the first witness on the bill, Miss Diana Bremen. There you go. Now you go. Yeah, unmute yourself, and the timer will start as soon as you start.
Thank you, Madam Chair, and the members of the committee for providing the opportunity to testify in support of House Bill 370. My name is Diana Bremen. I'm an educator with the Anne Arundel County Public Schools. I'm also a person living with epilepsy. At the start of each school year, teachers are trained on several health issues, such as reacting to allergic reactions, diabetes, and sickle cell anemia. As I sat in this training, it occurred to me that if one of my students or a teacher had a seizure, no one would know what to do. After my own diagnosis of epilepsy in 2018, I began researching. I learned that there are 6 to 10 students with epilepsy in every Maryland public school. Last year, my hallway alone had 2 students and 2 teachers, including myself, with epilepsy. In the United States, there are approximately 470,000 school-age children with epilepsy versus 208,000 children with diabetes. I'm not dismissing the seriousness of diabetes, but our 8,000 students and staff who may experience a seizure at school should have the same protection. To someone not trained, seizures may appear to be something different. For example, an atonic seizure, once referred to as a drop attack, mimics fainting. Myoclonic seizures, which are sudden involuntary muscle jerks, could resemble a tic. Absence seizures, which are extremely common in children, are a blank stare. The child would appear to be unfocused or daydreaming. Teachers could confuse this type of seizure with ADHD. We need to know the signs of seizures. Parents trust that the staff will keep their child safe at school. Should there be emergencies, teachers are the first responders. It's critical that teachers know the correct safety measures to protect their students. Under this bill, teachers would be provided with individualized seizure action plans for each student with epilepsy so they may respond appropriately. We need to correct old, dangerous ways of thinking, such as putting things in the mouth of someone experiencing a seizure. As training explains, we can save a child by using stay, safe, side. Stay with the child. Keep them safe from things that may hurt them and time the seizure. Roll the student to their side. There may be questions about the financial responsibilities for training school staff across the state. Fortunately, the Epilepsy Foundation has already developed a 45-minute free training. 45 minutes is nothing to save the life of a child. In requiring seizure recognition and first aid response training for school personnel, we are creating safe schools for those who may have a seizure. So I'm urging you to please pass House Bill 370. And to answer the question regarding IEPs, this is not an IEP concern. IEPs address students with learning disabilities. 504s would only be necessary if the seizure has an impact on their academic ability. This is a first aid safety plan.
Ms. Diana, I think you get a gold star today. You gave your testimony and answered a question at the same time in under 3 minutes. So thank you for that. Any questions actually, we're going to go to the next panelist first, and then we're going to take questions from folks. Let me just find this thing. The next panelist would be Lauren DiBietito. I'm sorry, I tried several times.
No, that's fine. That's fine. DiBietito.
Okay.
Thank you all for allowing my son Gavin and I to speak today in support of Brindley's Act. I have a picture to share with you. This is a picture of Gavin's preschool class photo. It was taken in 2016. Gavin was 4 at the time. He was a happy, healthy, typical little boy. About 1 year after that photo was taken, 2 unprovoked seizures led to an epilepsy diagnosis for Gavin. 2 years after diagnosis, his epilepsy became drug resistant. Since that time, Gavin has had countless hospitalizations, many missed days of school, and he even took on brain surgery, like a champ. He currently takes 4 AEDs twice daily in an attempt to make it through the day without seizures, but even still, they persist. Another child in that same preschool class, Katie, went on to have a single seizure in the summer of 2019. Coincidentally, Katie's mom brought our family a meal in the days following Gavin's surgery. As a friend who lent support and a sympathetic ear, she was aware of the various ways seizures presented and how to respond from our experiences. It was this awareness that allowed her to act with knowledge during her own daughter's seizure. The day that class picture was taken, no one would have predicted epilepsy and a seizure would become part of Gavin and Katie's story. So that really speaks to the statistics here. I strongly believe that this legislation will give our school communities the tools to act from a place of awareness, knowledge, and preparedness when handling seizures. When I talk to other parents of children with seizure disorders or epilepsy, I hear a common theme of an inconsistent and patchwork response to these students' needs. This legislation is quite urgent in allowing us to do better for them. And my son Gavin is actually here. He's kind of a little bit low in thing and he'd like to just say something.
Hi, my name is Gavin. I am in 3rd grade at Central Elementary School and I have epilepsy. When I have a seizure, I need other people to know what to do to help me and keep me safe. Please make the schools in Maryland seizure safe. Thank you.
And I'll add too that Gavin doesn't qualify for an IEP. So a lot of this training and the attention to his medical needs would not also fall under that type of plan.
Man, Lauren and Gavin, you both get a gold star too. 2 speakers in under 3 minutes. I love it. Great job, Gavin. I appreciate your testimony.
So a lot of this training is
There we go. Okay, so we're going to go to our next speaker with favorable, Lauren Schillinger.
Hi, thank you so much to the chairman and to the vice chair. My name is Lauren Schillinger and I'm Brinley's mom. I'd like to thank the committee today for hearing our panel's testimony. I'd also like to share a picture. My daughter Brinley is the face behind this Brinley's Act, and I'll be speaking for her since Brinley isn't able to speak for herself as a kindergartner. At 9.5 months, Brinley began to have complex partial seizures, and we were referred to Children's National Hospital. After an EEG and full body scans, she was diagnosed with epilepsy as well as a rare genetic disorder called tuberous sclerosis complex. TSC is a genetic disorder that causes tumors to grow in all your major organs, and it's the leading genetic cause of both epilepsy and autism. Doctors prescribed Brinley numerous anti-seizure medications, but unfortunately they failed to work for her, meaning that at her worst, she had 25 seizures a day. In October of 2016, Brinley had 2 brain surgeries like Gavin to remove part of her brain. And thankfully, the surgery did reduce her seizures, but the reality is Brinley still has seizures today, and unfortunately had a seizure today. She continues to take anti-seizure medications daily, and we also carry a seizure rescue medication at all times, and that's to interrupt a dangerous cluster of seizures or a seizure that won't stop, potentially leading to brain damage. I started to worry about how this would impact Brinley's future. How would it change her life? Would she be able to attend school? We met with her team a few years ago when we prepared for preschool and shared our concerns. And honestly, team, I was as anxious as when we handed our daughter over for brain surgery. Her team told me day one, they were equally scared. They had never been trained on how to handle students with seizures, didn't know anything about seizure rescue medications. And while other friends were out buying backpacks and getting excited for school, my time was being scared and anxious and determining how I could train myself on my own, how school members would handle my daughter's condition. Would they recognize a seizure? Would they know how to help her? And who would administer medications? Now that Brinley's in her 2nd year of kindergarten, we still continue to have these concerns daily. And we are very worried that this concern, if this isn't passed, will continue from kindergarten until she graduates high school. The American Academy of Pediatrics reports that seizures are in the top 3 for school emergencies, and we have the support of that organization as well as the Maryland school nurses. By enacting this critical legislation, Maryland would be protecting almost 8,000 students with epilepsy and seizures, and not to mention those that'll have their very first seizure while attending school. If House Bill 370 becomes Brinley's Act, 16,000 Maryland parents like myself and my husband would certainly rest better at night knowing our children are as safe as possible in our schools. This critical 45-minute training is free and already created by the National Epilepsy Foundation, and the foundation is headquartered here in Landover, Maryland. The training is going to be reduced. It is in progress to actually become a shorter training because we know 45 minutes might just be on the cusp of a hair too long, but we are having a new training created now that will be slightly shorter. It's online and free.
Hey, Ms. Schillinger, can you
yes.
have your last sentence, please?
Yes, I am. Yes. Basically, children can die from seizures. If they're not responded to in a timely manner, there can be permanent brain damage, and passing this bill makes our seizures, our school seizures safe. And we would love for the support and to vote yes for Brinley's Act. Thank you for your time.
Thank you. Okay, our next speaker we're going to have is Robin Elliott.
Good afternoon, Robin Elliott. I'm here today with the Maryland Nurses Association in support with this bill with amendments. We wanted to thank both the House and the Senate sponsor, as well as a sincere thanks to the advocates for working with us. You'll hear from in a moment from my colleague from the Maryland Association of School Health Nurses in greater detail. But essentially what we did is we looked at the bill and we suggested amendments that make the bill align with other parts of the law and guidelines that relate to the role of school nurses. And principally, we're always very careful around making sure that school nurses are involved in decisions about medication administration and who is competent within a school to do that. So we appreciate consideration of those amendments. And again, thank the sponsors and the advocates for working with us.
Thank you very much. Our next speaker we'll have is Christy Gorman, and then we'll take questions.
Hi, I'm Christy Gorman. I'm the president of the Maryland Association of School Health Nurses, and I'm also an elementary school nurse. School nurses serve in a pivotal role that bridges healthcare and education. Children with unmet health needs have a difficult time engaging in the educational process. Children with chronic and complex medical problems, such as epilepsy, they're coming to school in increasing numbers and deserve access to their treatments in school so they are ready to learn. Until Maryland can have a full-time registered school nurse in every school building all day and every day, it's important to have measures in place to keep children like Brenly and Gavin safe and healthy so they can remain in school and ready to learn. I appreciate having the opportunity to speak with the bill sponsors and advocate for this bill. Sorry. Our discussions involved clarification that school nurses remain the point person for medication administration and to ensure that the bill's provision align with the Nurse Practice Act. And after our discussion, we did come to an agreement to ensure that the bill is now consistent with school health guidelines. So thank you again to the sponsor and advocates to their commitment to ensure all children can participate in the education system. And I also want to thank Delegate Kerr for pointing out yet again that our students in our schools deserve access to such individualized health care.
Thank you. And so we're going to take questions now for this panel. Miss Delegate Belcastro from HGO.
Thank you, Mr. Chair, and thank you Ways and Means for letting me crash the party from HGO. Is in my full-time job, I'm a special ed teacher, so we deal with seizures quite frequently in our program. And another piece of our program, and this is true for many programs across the state, is we do weekly or bi-weekly community-based trips. So we've had many times when our students, when we're on these community trips and out in the community, we've had seizures happen. So my question is, it says that we're targeting 2 adults within the school for this training. Are we thinking or considering about teachers who might be, who will see students most frequently that are prone to seizures, and also those teachers that are frequently leaving the building because they're going on these community trips? That's it.
Could one person answer this question, one of the panelists?
Yes, this is Lauren Schillinger. Am I allowed to answer?
Sure, absolutely. Go ahead.
Okay, thank you. Yes, so the training would be available to all that are working with students like that. The 2 specifically that are indicated in the bill are directly addressing at least 2 people that are trained to administer seizure rescue medication. So the number of 2 is specifically talking about those that would be taking it just a hair further, a little bit of a step further, and learning how to administer rescue medications based on a student seizure action plan.
Got it. Thank you so much for the clarification. I came in a few minutes late coming over from HGO. I appreciate it.
Thank you, and welcome to Ways and Means. Best committee there is. Delegate Lukey, you're next.
Thanks, Mr. Chairman. Delegate Belcastro, HGO is pretty good too. You guys are okay. Robin, I have a question for you. So, I mean, I like a lot of the stuff in this bill, and I think it makes a lot of sense. But I do think it needs some amendments. And you mentioned some before. I noticed that towards the end of the bill, there's a liability shield specifically in the bill. I mean, isn't there an existing liability shield for first aid provided in school? Doesn't that come under the damages cap that exists?
So Delegate Lukey, I'm not sure. That was not our focus when we looked at the amendments, but perhaps one of the main advocates for the bill may be able to answer that.
Okay.
Yeah, is one other person can answer that question?
Lauren again, thank you. Yes, so we just modeled the language from other bills where this legislation has already passed, where we were encouraged to have a Good Samaritan clause, but certainly we would be open to, for any reason, any legislative language that needed to be adjusted amendment-wise regarding that clause. We certainly would be open to that if we already feel there's protection in place for that.
Okay, cool. Thanks.
Thank you. Delegate Ebersol.
Thank you, Mr. Chair. I just want to clarify that we talked about 2 people being trained, but the bill actually, I'm looking for confirmation, looks for all teachers, administrators, and various other people who deal with students to be trained each year in this training. Is that correct?
Hi, Diana Bremen. I'll clarify. So the training would be for all staff or personnel. It would only be at least 2 in administering the emergency rescue medication.
It says provide annual training to administrators, faculty, therapists, guidance counselors, classroom aides, drivers, contracted employees, and any other school personnel who directly contact or have supervision of students. So this is everybody.
Yes, we want them to be safe in
everybody
in the bus.
Just everybody every year has to go through this training, has to have training. Okay.
Yes, and that's similar to diabetes or allergies. We are trained yearly on those.
Mm-hmm. Yeah, I have some experience. Thank you.
All right, Delegate Lukey, your hand's still up. Nope, good. Okay, great. I don't see any other questions for this panel. Thank you, everyone on the panel. I think we have just a couple more. Let me just check. I think they all are written. So that concludes the public hearing for this bill. Madam Chair.
Thank you, Mr. Vice Chair. Thanks for taking over there. House Bill 96, Delegate Solomon.
Thank you, Madam Chair. Thank you, Mr. Vice Chair. Colleagues, it's good to be with you even on Zoom. For the record, Delegate Jared Solomon, and I'm here to present HB 96, the College Aid Equity Act. And I wanted to also recognize my colleague, Delegate Rosenberg, who I know is with us as well. We worked hand in glove on this, and also wanted to thank many of the folks on the committee who offered advice and perspective as we were working through this bill. So really appreciate that. What this bill would do is would require each public school student in Maryland beginning in 23-24 academic year to submit a FAFSA form, the free application for federal student aid, or the Maryland State financial aid application, the FAFSA or MISFA, as part of their graduation requirement, with obviously robust waiver process as well. We know how important college and post-secondary career opportunities are for lifelong earning potential, yet we know that students who live in poverty, students of color, and first-generation college goers historically experience disproportionately lower rates of college enrollment and completion. Low-income students are only half as likely to complete college as their higher income peers. The COVID situation, frankly, has just made this even worse. Among the high school class of 2020, college enrollment overall has declined more than 20%. And among students who come from high poverty high schools, it's down 33%. So we're potentially looking at what could be called a lost generation of college students. Given what we're experiencing, we have a really unique opportunity, I think, with this bill to really eliminate some of the financial gaps and barriers. And in Maryland, our situation, frankly, is not really all that great when compared to other parts of the country. We have a couple of counties in the state where the FAFSA completion rate is as low as 35%. And we know if you complete the FAFSA, you are 84% more likely to immediately enroll in post-secondary education. And for low-income students, it's actually 127% increase in immediate college enrollment. Overall, we only have about a 64% completion rate of FAFSA in the state of Maryland, meaning our students are literally leaving millions of dollars in not only state aid, but federal aid on the table. So really, I think, again, this bill is a perfect intersection of timing. Obviously, we all did incredible amounts of work on the Kerwin bill and the blueprint, which, would enable all of our students to be theoretically college and career ready. And we want to make sure that they can afford college. And most recently in December, the federal government passed really historic changes to not only make the process of the FAFSA so much easier, reducing the number of questions by almost 70, but also dramatically expanding access to Pell Grants and federal aid, making 600,000 new students eligible each year for federal aid, and over 1 million students eligible for a full Pell Grant. So what does the bill actually do? And I wanted to just sort of point out, we made extensive amendments to this, and I literally just got an email about 2 minutes ago from the amendment office. So I think the amendment has been drafted, but in my written testimony, there's plain language of the amendments. It's about, again, almost 2 pages worth. We've been doing an incredible amount of work on this bill with education groups across the state since November. So if you don't have the actual amendment language, again, I would refer to my written testimony. There's a document in there, but I did just sort of want to point out sort of 5 major changes that we've made to the bill in its from the form that it was introduced as. The first is we made the first year a pilot year. So while the bill would officially go into effect in the academic year 22-23, that would be a pilot year with no actual requirement, and schools can volunteer working with MSE and MHAC to sort of roll out the process. The following year, 23-24, the actual requirement would go into effect. The other major change we made is to the waiver process. So we modeled this off of what the state of Texas has put in place. So there's 3 states, Illinois, Texas, and Louisiana, that have implemented this. Louisiana is the furthest along. They were the first to do it. But we changed the waiver requirement to make it, frankly, much easier. So students have 3 options. A parent can sign a form. If a student is over the age of 18, they can sign the form on their own. Or for particularly difficult circumstances, if a student is undocumented and may not want to share, or if a maybe family has tax issues that they don't want to share, a student can essentially just have a conversation with a guidance counselor or another designated official, and they can be waived out of it for good cause. But the idea here is at least that conversation has taken place, and students sort of know the process and what could potentially be available for them. The other major change we made was we created an advisory committee to not only advise MHEC and MSDE on the regulations and sort of put out best practices and materials and guides for school districts, but also to really provide advice and support on the entire verification and aid process that MHEC runs, which we know is not ideal. It's something on the Appropriations Committee we're trying to spend more and more time looking at, but we want to bring the best people, the best minds in the state from K-12 education. We want students from high school and college to be part of this as well, to provide advice not only to MSE and MHEC, but to the General Assembly as well on how to implement this, to analyze data on a regular basis to see how this is actually being rolled out. And then lastly, we changed this to the original bill says submit and complete. The completion of the FAFSA process is actually, requires a couple of additional steps, oftentimes that take place sometimes even after the school year is over. So we changed it to just submit, not complete. Lastly, the point that I wanted to make was, again, Louisiana is the one state that has really actually implemented this already. Texas, the new requirement goes into effect the next school year in 21-22, and Illinois just literally started it, but Louisiana actually has data. And so in the first year that Louisiana put this into effect in 2018, there was a 25% increase in FAFSA completions. And the state went from the worst in the country to first and the best. Post-secondary enrollment among Louisiana graduating seniors increased by 7%. And it absolutely narrowed the gap to almost nothing between rich schools in the state of Louisiana and schools in poverty. So it really had an incredible effect for what was a pretty low cost way to increase FAFSA. The last piece I'll mention before I turn it over to some of the folks who have signed up to testify, you'll see in your in the written statements that were submitted, really a wide-ranging array of groups. We have support from MSEA, we have support from the Maryland Association of Boards of Ed as well, who we worked with extensively on the amendment, groups from the NAACP, who will be with us today, as well as CASA. And the last point that I just wanted to point out was I know the graduation requirement often is something that, people, it's a line in the sand that people don't want to cross. I think, again, you'll notice in the testimony from MABE and MSEA is, they viewed this differently. And we worked together to really come up with a bill that, although both of those groups often will never want to add anything to the graduation requirement statute, they felt like this was so important, particularly, again, building off the work that we've done with the blueprint, that they both support the bill and have worked, again, hand in glove with us to make sure that this bill reflects the views that they had. So thank you for the opportunity to testify, and I hope that we can get a favorable report on the bill.
Thank you, Delegate Solomon. First person to speak is President of our Community College from Montgomery County, Dr. Darian Pollard. Welcome. Good to see you.
Good afternoon, and thank you, Madam Chair, and good afternoon to all the members of the committee. I'm deeply pleased to be here, and I want to thank Delegate Solomon and Delegate Rosenberg for advancing this bill. I think during these most uncertain times, I ask for your support of this legislation to make college education more certain for Maryland residents. I strongly endorse and urge this committee to adopt House Bill 96 to make the completion of the FAFSA a requirement. I think this requirement, as Delegate Solomon mentioned, paired with the new changes coming based on recent action at the Capitol Hill regarding financial aid will put the dream of college education within the grasp of so many more. This committee knows very well the challenges that many students face in order to afford post-secondary education. You know that nationally, less than 8% of students from the lowest income quartile complete college in a timely fashion. And this committee also knows that the hardworking part-time student often does not complete at all. The data suggests to us on a national level that less than 8% of such students complete an associate's degree within 4 years of their high school graduation. You know that making ends meet in a particularly challenging time for so many families, particularly as we look at Maryland's future as we attempt to rebound our economy in this particular pandemic that we're experiencing. I believe this is why you adopted the Community College Promise Scholarship to enable more families to afford college education. But here's the problem. Many families do not think that college is affordable or a glimmer. They worry about finances. They don't think it's accessible to them. And I speak from this because I know for a fact this was my own story. The reality was this, is that as a family, we knew that I wanted to go to college, but none of us could think about how to afford that. And more importantly, my father did not understand the importance of the FAFSA form. I know that my story only represents the lived experience of so many other students who step into higher education uninformed and oftentimes unengaged in this. This is an opportunity to level the playing field. And we know with the adoption of this particular legislation, more students will complete the FAFSA and know that they can afford college, and more students will attend college, hopefully completing and joining the talent pool that we know is necessary in Montgomery County and certainly in the state of Maryland. I'm speaking to you obviously as a community college president, but I'm also speaking to you as someone who is here because my father was encouraged to complete the FAFSA form. Please vote to give House Bill 96 a favorable report. And I thank you, and I'm very pleased to be in here today. Thank you.
Thank you, Dr. Pollard, and to everyone else, since there's quite a few people testifying on this bill. Everyone does not have to explain the dynamics of how the bill works, as Delegate Solomon did. So thank you, Dr. Pollard. Good to see you. The next person that we have on the list is Dr. Antoinette Coleman, Associate Vice Chancellor for Academic Affairs at USM.
Good afternoon. Thank you, Chairman Kaiser, for the opportunity to testify on House Bill 96. One of the most important things, as we have heard, is that there needs to be a clear financial pathway to affording college. And as my colleagues have said, this bill will provide that opportunity for a broad range of students. Many low-income students, as you know, do not have the backing support to proceed to college. The FAFSA and the Maryland application for financial aid does. It affords so many students on that end of the spectrum. But we should not forget the students who are in the middle, and particularly those students whose families have been faced with the impact of COVID. They've lost their jobs. They were one time the middle class. Now they slipped into another category. And this bill will help them understand as early as their child is in high school to complete the application. As USM, we have provided many decades of financial aid services to students, working with students to complete the FAFSA form and the Maryland State financial aid application. But one of the most notable things is when we go back to look at 2014, there were only about 44% of the high school students who completed the FAFSA form at that time and received federal financial aid. In this period to date, we've only increased about 10%. That is not a great jump for our students. Currently, USM enrolls 132,385 students. The number of students that receive financial aid includes 62,219. The number of Pell students includes 37,142. Pell students represent only 28.1% of our financial aid students. Why? Because many of the students do not complete the FAFSA form in time to be packaged for financial aid. This is our fall 2019 data. What we would like and really would like to see going forward is that many, many more students are properly packaged, receive the type of aid they need, and no money is left on the table. USM would like to ask for a favorable report to House Bill 96. Thank you.
Thank you very much. Andrea Sapola, Director of Financial Aid and Scholarships.
Good afternoon, Madam Chair and other members of the committee. Thank you for allowing me to be here today to speak out for House Bill 96. I am currently the Director of Financial Aid and Scholarships at University of Maryland, Baltimore County, and I have over 20 years of experience in financial aid field. UMBC is in support of this bill as well. We are a public research university serving a student body of just over 25% first generation, and almost 30% of our student population are Pell eligible students. So we know how important financial aid can be for our students. This bill creates an opportunity to educate every Maryland student, as well as their parents and guardians, about the financial aid process and opportunities that are available that they may otherwise not be aware. For some, it could be life-changing. We know the FAFSA can be intimidating and overwhelming for students, but even more so for our first generation and low-income students who don't have that family member who have gone through the process, who might be able to lead them and guide them. But it is a critical first step to having these students enroll in college and be able to reach a degree. The burden on students will be reduced substantially with the 2023-2024 FAFSA application, as Delegate Solomon mentioned, when the number of questions on the federal application is reduced from 108 to 33 questions. Many of those are income questions that would be completed automatically through the IRS data link. We were also encouraged to see language in the bill regarding waivers. For our neediest students whose parents are absent, disengaged, or simply unwilling to comply, their prospects for attending college are already diminished. The waivers prevent additional roadblocks in getting their high school diploma. The waivers will also give the needed flexibility for students who opt for a future in the military, or who decide that college really isn't their path and choose to start their career straight out of high school. Finally, our hope is that implementation of policy is at the state level and enables consistent practice and support for students regardless of the county they live in or the high school they attend. So we at UMBC do urge a favorable report on House Bill 96. Thank you.
Thank you so much. We next have Rachel Lastombo from College Tracks.
Yes, hi, thank you so much, Chairperson Kaiser, members of the House Ways and Means Committee, for this opportunity to testify in support of House Bill 96. My name is Rachel Lastombo. I live in Kensington, Maryland. I am Assistant Director for Success at College Tracks, a nonprofit organization in Montgomery County that works in partnership with MCPS. Our mission is to help first generation to college students, students of color, and students from immigrant or financially stressed households get into and through college. We strongly believe that all young people in Maryland deserve the opportunity to attend college if they choose and to have access to financial aid if they need it. And the only way to get this aid is by submitting FAFSA or MISFA. Surveys show that the primary reasons students don't submit FAFSA are because they think it is too complicated, they believe they won't be eligible for aid, or they don't know that financial aid exists at all. With mandatory FAFSA and MISFA, all students will gain a critical understanding of financial aid, opening the possibility for many more to attend college. At College Tracks, we're currently working with close to 1,000 students from 5 MCPS high schools and over 500 college students. So far, 70% of our high school seniors and over 50% of our current college students have submitted FAFSA for the next school year. Our goal is to reach close to 100% by the Maryland state deadline of March 1st. A high school diploma is no longer enough to provide a stable economic future. As of 2019, over 66% of all jobs in Montgomery County require some higher education. College degree holders have a dramatic positive impact on local and state tax revenue and consumer spending and are less likely to require government assistance. In Montgomery County, more than 40% of high school graduates from low-income families and families of color do not enroll in post-secondary education. Research has shown that completing FAFSA correlates with increased college enrollment among low-income students. We believe this is the right time to make FAFSA or MISFA completion mandatory. We want Maryland students to benefit from the recent changes to FAFSA passed by Congress that will make the form simpler to submit and expand the eligibility of the Pell Grant. Every high school student in Maryland deserves the same attention and opportunity to receive aid as our college tracks students do. The relatively small cost of ensuring that students complete the FAFSA or MIFSA is offset many times by the positive impact of expanding our regional pool of degree holders. It is for these reasons that College Tracks fully supports House Bill 96. Thank you so much.
Thank you. And we'll take 3 more people and then take some questions. And then there's a few other people signed up. Next, we have Victoria Uceda. Sorry if I've mispronounced your name.
Hi, good afternoon. My name is Victoria Hoyosada. I'm an MCPS alumni from Watkins Mill High School. I'm currently a 3rd-year student at UMBC studying geography and environmental systems, and I plan to pursue my PhD after graduation. I joined College Tracks after high school for support to gain knowledge on the process of applying higher education. Growing up as a first-generation and low-income student, there was no discussions about the process of applying to higher education at home. My father was an immigrant who came to this country and never learned the opportunities of higher education. Without applying to financial aid through FAFSA, I would have not been able to afford going to college. Being in College Tracks in high school gave me the support that was not available at home since there was a language barrier and no one in my family has ever attended college. The process was very daunting to me and my parents, but with the help I submitted FAFSA, which allowed me to have the financial aid I needed to go to college. I believe that it is essential for seniors in high school to apply for financial aid. Without financial aid, I would have not been able to afford going to college and I would have been stuck on a path that was not meant for me. Many students who share a similar background to me worry about the affordability of higher education. I hope that if more students have access to financial aid, these fears can be eased and allow them to see the possibility of attending college. The only way for them to see these possibilities is applying for financial aid. Thank you.
Thank you so much. Next person, Willie Flowers from the NAACP.
Good evening, Madam Chair, members of the committee. My name is Willie Flowers. I'm the Maryland State Conference president of the NAACP. We are supporting House Bill 96, College Aid Equity Act, for a lot of reasons, but it pinpoints the details about really valuing students who don't fit into a range. I just happen to work in Baltimore City and I live in Ellicott City, so I see the challenges that young people have who don't have the resources, not just to consider college, but the intimidation of it. It really hits me home with me when I hear poverty, student of color, and whatever challenge that you put, a category you put students in, because I was one of those students at the age of 16 or 17, and I had a chance meeting with my, it was a home ec teacher who actually saw me with this very intimidating pieces of paper. And she said, "Is that your financial aid package?" And I said, "Yeah," after not being able to really get a hold of it myself. But she sat down and her name was Miss Oggs, and she helped me to do every piece of the form. And I didn't realize how significant that was until years later when I was in college and students had to leave because they didn't have financial aid and this kind of thing. So I think that this bill speaks to not just creating an outlet for students, but valuing them even if they miss the cut, because it is the case that life moves fast in challenged situations, challenged communities, and a deadline can be mean life or death for some families, for some students. And this bill assures that students will have the ability to choose a college, get there, and they'll have options about financial aid. In my case, I was able to have Pell Grants, student loans, and scholarships, and I eventually had a work-study job that was all because of filling out the application that day. And I don't think that it would have been more challenging for me to do. Maybe it would have happened, but I know that the pieces of my family at the time, I was the first person to attend college in my family, first person to go through that process. And I think that this bill assures students who are in that same situation will have an outlet to college and outlet to a life that could reverse the challenges they have. So the Maryland State Conference NAACP, submits a favorable report for this bill, and I hope that the committee can support it. Thank you.
Thank you, Mr. Flowers. Next, we have Baltimore City Council Member Zeke Cohen. Welcome.
Thank you. Thank you, Madam Chair and delegates. And thank you for this important legislation. I'm a former Baltimore City public school teacher. I taught in West and in South Baltimore. And one of the things, and Mr. Flowers just spoke to it, that we know about children in Baltimore is that they have limitless potential. I taught some of the smartest young people in the world, some of the most resilient and scrappy young people in the world, but whose limitation was really finances. And a lot of the young people that I taught and that I worked with through an after-school program didn't have parents who had been through college, needed some support in navigating the financial aid process. And more often than not, what I would see is young people become extremely discouraged by how complicated, complex, Byzantine, confusing it all really was. And in some cases, young people weren't being encouraged within their schools to fill out the FAFSA form, and it became a real problem. I remember one of my very best students, a young woman who was several times smarter than I am, who came from very difficult circumstances, was first in her family to be accepted into a college, I believe was the first in her family, in her immediate family, to complete high school. And she got into my alma mater, Goucher College, and she was looking forward to going there. But there was a huge challenge within her high school with the guidance counselor not knowing how to help her on the FAFSA form, and with her teachers being overworked and overstressed. And ultimately, because we nudged and prodded, she was able to fill it out at the last possible second and get her Pell and her financial aid. But it could have been catastrophic. It could have meant the difference between her going or not going to college. So to conclude, I believe this legislation is so important because filling out the FAFSA needs to become embedded in the business of what schools do. Young people in high school need that additional support, particularly children who are first in their family to go to college or living in poverty. And so I urge a favorable report, and I thank you for the work that's gone into this legislation.
Thank you, Council Member. To this entire panel, we have a few questions, starting with Delegate Patterson.
Thank you, Madam Chair. Thank you very much for Delegate Solomon and Rosenberg bringing this very important legislation before us. I have one question, really two, in terms of how it operates. We certainly know that it's really critical to have the information completed because it includes the parents' income status as well as the home situation in terms of dependence. So are you looking at having the schools create the operational procedures, or are you looking at maybe having someone designated as a person to help with the FAFSA? That was one. And the second part to that is the advisory committee. We know that TRIO the federal programs, working with high school students, for example, Upward Bound, Talent Search, that is one of the criteria for first generation and low income. Are they considered part of your advisory committee? And if not, I would encourage you to look at those programs.
Thanks for the questions, Delegate Patterson. I'll answer the first one or the second one first. We tried to kind of make it a catch-all with any sort of college, college official or outside nonprofit group. So if TRIO for some reason wouldn't fall under that, you're absolutely right.
Absolutely.
In my old capacity, they're a wonderful program. So we'll make sure that they're covered under it. And then to the first question, we really wanted to sort of leave it up to the schools, frankly. So the idea of this advisory committee is, again, bringing sort of the best minds in the business in our state to come up with the best practices. And it may look different in some schools than others. College Tracks does amazing work in some of the high schools, even in my district in Montgomery County and Baltimore City. College Bound and Prince George's first generation College Bound. We've talked a lot with Joe Fisher, does amazing work. So for some places, it may be better to have somebody within the school to do it. In other places, it may be better to partner with a nonprofit that already has a really established community presence. So we didn't want to lay it out. We wanted to just say, at the end of the day, as long as you can verify that every student has at least had the opportunity to fill it out or had a conversation around it, that's the most important piece.
Thank you very much.
Thank you. We have a few other questions. Delegate Feldmark.
Thank you, Madam Chair. And I really just want to clarify my understanding. I mean, I think I really appreciate this concept. The bill synopsis refers to it as a requirement. It seems like there's a pretty broad and easy opt-out, but I wasn't sure, are there specific criteria around what allows a student to opt out, or it's just making sure that it is an active opt-out?
Yeah, thanks for the question, Delegate. Yeah, so we wanted to leave it broad. Again, the intention here is we wouldn't want to actually prevent a student from graduating. So in addition to the waiver that a parent can sign, or if a student is over 18, we left the sort of good cause language in there a little bit broad. And that's an ongoing conversation actually with in the amendment process and with the committee council, is whether we need to sort of define some examples of what good cause looks like. But we wanted to, again, that's modeled off of the state of Texas, which, has an even larger undocumented population than us. And we wouldn't want students to be, really penalized or harmed because maybe their parents did something that they don't want to divulge. So yeah, we wanted to leave it robust.
Okay, thank you.
Thank you. Delegate Lasanti? You're unmuted, but we still can't hear you. Try again. Now you're muted.
Now, can you hear me okay? Sorry about that. Thank you, delegates, for this bill. I think it's a very interesting bill, and I think one of my questions was already addressed about the opt-out. But I want to go back to the basic assumption. Is the basic assumption here that every student should go to college? It's kind of the lead-in to my question.
Yeah, so that's an issue that a couple of people have raised, actually. Thank you for bringing it up. No, you may have a student who says, I'm enrolled in an apprenticeship program, or, I want to go into the military, or I'm interested in working. So again, we want to make this waiver process. That would be good cause. That would be totally fine. But we know, certainly there's additional work being done at the federal level. And I know it's an issue that we've talked about a lot in Maryland around making sure that our aid can actually go to credential programs. So if you want to enroll in, a welding program, or you want to enroll in, maybe a short-term, coding boot camp or something, that we would allow our state aid to be used for those kind of programs. And if we did, you'd have to complete this paperwork as well.
And I think that's important, that somehow we have some language while you're working on amendments that specifies that, because I just don't want us to give the impression that we're devaluing trades or any other thing that you want to do after college, that's not just the end all be all. And the second piece of this, and this may be minor, but the way I read it, maybe you're working on this in amendments, but that the assistance goes to the student. And I think it's really important that somehow that there is really assistance provided to the parent or guardian, because they really are the keeper of obviously the financial information. And, you know, and all of us, as we have scholarship programs ourselves that we are administering, we all find out that it's the parents that we're really engaging with so often, filling out that, and it's the parents that we're working with too. So if there's some way that we can engage the parent or guardian in with providing that assistance in filling out that the forms, because they are very, very complicated, I think that would be very helpful.
No, that's a great point. We'll make sure that we add that clarification in there. Thank you.
Great, thank you.
Delegate Solomon, I have a question for you. If we make this a high school graduation requirement, I believe students have to fill it out in the fall. How do you ensure that that's happening at that time? Is that part of what's in your bill as well?
Yeah, so that's a great point. So the FAFSA becomes out live October 1st, and we've one of the amendments we're working on was we didn't want to require it, but we wanted to try to make sure that it's actually you could fill it out even before the Maryland aid deadline, which I believe is March 1st, to qualify you for the state aid. You know, it's better than nothing. If a student were to complete it, you know, in, let's say, April or May, they're still eligible for federal aid. They may just not sort of get it as early as somebody else or get their award. So, you know, again, I think the encouragement here and through, you know, the process that would come from the advisory committee would be for schools to, you know, get this started as early as possible. You know, even sort of part of senior year orientation, or, you know, kind of the way that a lot of schools have integrated, you know, writing a college essay as part of an English class early on in senior year. But, you know, there'd still be a lot of benefit for a student that may qualify for Pell, and maybe they didn't think they could go to college to complete it, you know, in April or May.
All right, thank you. I want to thank you to that panel. We do have a few other people signed up for this bill. Let me call on them. One moment, please. We have Andy Clark. Is Andy Clark here?
Yes, Andy will not be testifying.
Okay, thank you. And then next we had Laura Stewart.
Good afternoon.
If I saw you here.
Yeah, you can hear me? Okay. Good afternoon. My name is Laura Stewart. I'm the Vice President of Advocacy of the Montgomery County Council of PTAs and a proud parent of a sophomore at Albert Einstein High School and a sophomore at University of Maryland. MCCPTA represents over 25,000 members from over 200 school communities. We support HB 0096, the College Aid Equity Act. This bill will ensure that all students that qualify for financial aid will have an opportunity to access resources so they may continue with their education after high school graduation. Completing the FAFSA is an important step towards expanding opportunities for Maryland students. Montgomery County Public Schools reported FAFSA completion rate is approximately 5% below the rate it was from 1 year ago. Let's face it, filling out these forms can be confusing and time-consuming. Schools do offer support, but these messages often get lost in the many messages parents get in the senior year. And if you're financially insecure, you might not realize that college can be accessible with financial help. This bill will encourage school systems to provide significant and individual support and outreach to students that might otherwise forgo opportunities. For low-income students, FAFSA completion is associated with a 127% increase in immediate college enrollment. The investment in time and effort in adding this graduation requirement will ensure that Maryland students will not miss out on millions of dollars in federal and state financial aid. By passing Bill HB 0096, lower-income students in Montgomery County and Maryland will have more opportunities to continue their education, increase their earning potential, and achieve their dreams. And for this reason, MCCPTA recommends a favorable report on HB 0096. Thank you for allowing me to testify on this today, and I hope to see many of you in the future. Thank you.
Thank you, Ms. Stewart. Any questions for Ms. Stewart? All right, seeing none, we have one more person signed up, support with amendment, Mr. Willems.
Madam Chair, members of the committee, John Willems, representing the Maryland Association of Boards of Education. Pleased to be here today to testify in support of this bill with amendments. The amendments were thoroughly covered by Delegate Solomon. Want to thank him for his good faith effort to reach out to us well in advance of session and to work through a series of pretty substantial amendments. Yes, the word requirement makes us cringe. We have pushed back against high stakes graduation requirements based on statewide standardized assessments over the years, pushing back against some state board and State Department initiatives that would have had 40% of our seniors not graduating in at least a couple jurisdictions. And so it is a pivot for us. And so to be brief, I just want to emphasize that our support for this bill does reflect that our platform for 2021 does much more intentionally and obviously include the restatement of our equity core value, our equity lens, our definition of educational equity at MABE. And we do view this as a bill that represents a distinct pivoting of what might traditionally be a position of opposition to working out amendments to benefit students for whom access to higher education and programs following high school might not be available because they and their families perceive it is not a viable option for them based on income. And so it's going to be hugely helpful, we believe. We appreciate the pilot year, I think, most importantly in the advisory committee, so that we can build this and get it right before it poses any threat, if you will, to be something on which a student's graduation would hinge in a negative way. But we think the positive far outweighs the negative with regard to launching this initiative, and would appreciate a favorable report with the sponsors' amendments.
Thank you, Mr. Willems. Questions, Delegate Lutke?
Thank you, Madam Chair. John, do you smile more when you get to testify favorably on something? You looked very excited at the beginning of your testimony.
Yes, Delegate Lutke, I get much more excited. But in my personal life, I'm an optimist, but that's not a side of me that you all get to see on a regular basis. So I apologize for that.
Well, thanks.
Thank you. Any serious questions from the members? Delegate Washington.
Thank you, Madam Chair, and thank you, Delegate Solomon, for bringing this bill. And my question is, I'm sorry I hopped back in, but can you just briefly go over the amendments? I'm trying to go through your testimony, but I don't see the actual amendments in the testimony itself.
Yeah, it should be the actual amendment language that we submitted should be at the very, very end. After the testimony, I think there's another 2 or 3 pages of it. And Delegate Washington, we may have, I think we just got the official amendment language from the amendment office. But basically, sort of the big ones are we changed the waiver process to make it a little bit easier and a little bit more straightforward. We added a pilot year. So even though the bill goes into effect in 22-23 school year, the first year is really just a way to work the kinks out. And the actual graduation requirement goes into effect in 23-24. We created an advisory committee that really will play a very robust role in the regulations and actually carrying this out, while also analyzing the data and really providing, I think, a really critical lens of, frankly, the MHAC process as well, and giving advice to the General Assembly on how to make that better, and whether we actually have enough aid, at the state level, which I think is something that'll also be a piece of again, implementing the blueprint. And then just some other minor tweaks, and probably the other large one is we changed the language from submit and complete to just submit, because completion is an additional process sometimes that some students need to deal with.
Okay. It seems like what we're trying to get at is informing parents to fill out the FAFSA form, because it's not the students that fill out these FAFSA forms, it's the parents that fill out the FAFSA forms. So what we're doing is that under this bill, it seems like we're holding the students' graduation in the balance because they aren't filling out, because their parents aren't filling out the FAFSA form. I understand there's a waiver under this, but if the student doesn't fill out the waiver by the time they graduate, by the time it's time for them to graduate, then they're penalized based on what their parents do. And as a first generation college student and a parent and a recipient of a guaranteed access grant, and a mother who had 6 kids and worked 2 jobs on minimum wage, I understand that she didn't want to always be able to put her business or income out there, but I had to drag her to do it so I could go to college. But so it becomes very difficult for families. And I just want us to take that in consideration when you're talking about Black and brown families, that we're mandating a graduation requirement, not for the student to complete, but for the parent to complete. And I think that we have to think about that as we propose these types of pieces of legislation. I understand the intent, and intent is good, but I think we also might have and the question might be, should we invest more in services and invest more in ensuring that families understand the process and can help them matriculate through the process versus create another graduation requirement?
Delegate Washington, I completely understand your point, and thanks for sharing a little bit of your own story. And obviously, I'm a big supporter of the bill that you presented before our committee earlier today, and actually have spent a lot of time on the phone with Joe Fisher from Prince George's, and sort of talking through and thinking through the process of the bill. Again, in the waiver piece, that's why we added in that the good cause piece. We didn't want there to necessarily be a form that a student had to fill out, just going in and having a conversation with the guidance counselor to sort of spur the process and say, yeah, my parents may not want to participate in any of this whatsoever. And certainly if we need to make that good cause language a little bit more clear to make it, to reduce that burden. But I appreciate what you have to say, and look forward to working with you and your colleagues on getting this to a place where you're comfortable with it.
Madam Chairperson, may I also speak to that? This is Rachel Lastumbo from College Tracks.
No, I think that the delegates' questions were answered. This isn't the final stage with the bill. The Delegate Solomon will be working with Delegate Washington moving forward. So if you want to get something through Delegate Solomon, but I think he's already answered the question. Are there any other questions from members? If not, thank you very much. We're done with the hearing on House Bill 96. Delegate Solomon, you did not bring Leo along, so that might be a minus to you. To members, we have 6 bills done and 6 bills to go, but the other 6 don't have anyone testifying on them, though I believe Delegate Grammer brought a special guest, unlike Delegate Solomon, who was asked to bring a special guest.
He was napping. I apologize, Madam Chair. I will make it up to you before the session is over.
All right. Okay. So we're moving on. Delegate Grammer, House Bill 4, and please introduce your special guest.
Thank you, Madam Chair. This is little Lila. She is our COVID baby. She was born in February. She's closing on 1 year, and she's you see him? She's happy to be here with us, and we appreciate the opportunity to hear House Bill 4. For the record, Delegate Robin Grammer here to present House Bill 4. House Bill 4 expands the protections for the sale of caffeinated beverages in conjunction with career exploration activities to all schools in Baltimore County. We initially passed legislation to protect the schools that operated the program. We subsequently passed legislation that allowed expansion of this program. I believe it was to a school in the Speaker's District. We have again been asked to draft legislation so this program can be expanded to Parkville High School in District 8. The Fowles teachers advocate that the coffee stand model offers what best practices have found to be the most effective career exploration activity for students with cognitive disabilities. We hope to provide teachers and students the opportunities they are asking for when schools in Baltimore County resume a full schedule. With that, I will thank you for the hearing for House Bill 4, and I'm happy to take questions. And so is Lila.
Well, we just, we're all delighted to see Lila, no doubt. So
she's happy to be here.
Bring her every time, I'm sure. My daughter loves every Zoom and thinks they're all for her. So I can only imagine her enjoyment right now.
Yes,
any questions for Delegate Grammer?
Thank you so much.
All right. Thank you, Delegate. Take care. Next, we have Delegate Washington, House Bill 171.
Thank you, Madam Chair and members of the committee. For the record, this is Delegate Alonzo Washington here to present testimony in support of HB 171, School Discipline Data Collection Bill. This bill was passed out of the House, out of this committee unanimously, and it passed out of the House with an overwhelming majority of 132 to 1. I wonder who that one was. It wasn't me, I'm sure. HB 171, and I'm going to be very short because this bill did pass out of this committee unanimously last year, but HB 171 represents a recommendation from the Maryland Commission on the School to Prison Pipeline and Restorative Practices. That bill, that will expand accessibility of school discipline data and lower the threshold used to identify schools that disproportionately suspend subgroups of students. This is a great bill. It's a good bill because you all voted on it last year, and I ask for a favorable report. Thank you.
Thank you, Delegate Washington. Any questions for Delegate Washington? All right. Thank you so much, Delegate Washington. We're done with the hearing.
Thank you.
House Bill 171. Delegate Ebersol, House Bill 181.
Thank you, Madam Chair. House Bill 181 is a Baltimore County bill designed to change the way in which, in some circumstances, the County Board of Ed will elect its officers. The bill has not been heard in Baltimore County delegation yet. A quick description says that there are 12 members of the board. If there is a member who is not seated, that means not currently residing, holding the office. We had a board member pass away last year, and with 12 members, it still required 7 votes to elect officers. And this bill simply says if there are only currently 11 members occupying the office, it'll take a majority of them. In that case, it would have been 6. We presented it last year. It didn't make it all the way through. The Senate had a little dragged their feet a little bit. We will bring it before Baltimore County delegation this year.
All right. Thank you, Delegate. Are there any questions for Delegate Ebersol? Seeing none, I was mistaken. There is one person signed up on this bill, Aaron Parker.
No, that's on 237. That's the next bill. Sorry.
237. I was jumping ahead. I apologize. We'll wait for that. Anything else on House Bill 181 just presented? We're done with House Bill 181. Delegate Ebersol, House Bill 237.
And for the record, Aaron Parker is only here to answer questions that I'm not smart enough to answer. It might be a bunch. I don't think so. House Bill 237 is a repeat of a bill that was filed by Delegate Lutke last year. It's a response to the Ready to Read Act of 2019. It creates a stakeholder advisory group that's going to collaborate and make a reading and dyslexia handbook. The handbook will provide guidance for general and special educators on best practices to identify and remediate students with dyslexia and other reading difficulties by enumerating evidence-based instructions, intervention, etc. The bill also designates a dyslexia point of contact with the Maryland State Department of Education to serve as a sort of liaison and reference for educators around this. I need to make a note that the fiscal note has something that it had in it last year, which was an $87,000 position to hire for this. That fiscal note probably should have been updated since the bill was amended last year, where the State Department could use an existing position person to be that liaison. And we actually received a letter from the state superintendent over the summer indicating that she felt that that could be handled internally. So I believe that that expense would not be incurred. I request a favorable
Report.
Report. I don't know why the word ran away from me. I'm just getting old.
All right, Delegate Ebersol. Any questions, or and if there's any questions, should we just cut right to Ms. Parker to answer them?
Well, there are 3 small adjustments, but they're language adjustments. And if you want to know, she can certainly enumerate them, but they are really just updates of language that MSDE requested.
All right, members, any questions? All right, thank you, Delegate Ebersol. Thank you, Ms. Parker, for being here in case there were questions. Appreciate it. And lastly, to end the day, Delegate Smith, House Bill 320 and then House Bill 394.
Thank you, Madam Chair. You said 20 is first, correct?
Whichever one you want to do first.
Oh, it doesn't matter? Okay, yeah, since this is just me talking to you guys, I'll begin with House Bill 320. For the benefit of those who were not on the committee before, this bill actually passed out of the House, but due to the shortened session, we weren't able to get it out of the Senate. It's pretty straightforward. It's regarding the Maryland longitudinal data system. It's essentially just eliminating a middle kind of part of the process. So right now, under current law, the MLDS, for lack of the longer name, collects and maintains individual level student and workforce data. And currently, they receive that data through the Maryland, Higher Education Coalition. I think I'm using the wrong phrase. Sorry, I'm having a computer issue over here. The Maryland Higher Education Commission, rather. So we just really want to kind of, instead of having to go through the various agencies that collect the licensing data, having them send it to MHEC to then send it to MLDS, we rather just get the data to go right to MLDS directly without having to go through a middle person. So that's essentially all that this bill would do, is kind of streamline the central repository for the data to ensure that there's compliance with federal privacy laws, and that we can perform the research on the data sets more efficiently and effectively. So I'm hoping that we can receive a favorable report on House Bill 320. And again, it passed out of this chamber, earlier in 2020. So that's all from me. Are there any questions?
There are seemingly no questions, Delegate Smith. How about we go to your last bill, House Bill 394?
No problem. My computer is about to die, so I had to make sure I plugged it in before I lost what was in front of me. So House Bill 394, this is a bill that has actually passed out of the House twice. And it just seems to have some challenges when we get to the Senate. And it basically looks at the fact that the Maryland State Constitution requires a free and adequate education for all students. But if you're a student that has taken a class, you've been unsuccessful in passing the class, and then you need to take this class in order to successfully matriculate. So we're not talking about enrichment or bonus coursework, we're talking about core coursework. This bill would eliminate summer school fees for those courses, because across the state's 24 jurisdictions, there are school districts that charge nothing, and some that charge hundreds of dollars per course. So this is seen as an issue of educational equity, ensuring that all children have the opportunity to receive a free and adequate education. And in light of the pandemic, making it challenging for students to gain instruction remotely, I think it takes on even more of a heightened importance, that it would be even more unjust and inequitable to charge summer school fees in some instances and then none in others. So I hope for a favorable report on House Bill 394 as well.
Thank you, Delegate. Any questions for Delegate Smith? All right, seeing none, I'll knock my hands on the table. We're done with the hearing for today. Members, we have, trying to find my own calendar. We have a briefing tomorrow, I believe, and a hearing. On Friday morning, we have a briefing. I believe 2 of the subcommittees are meeting to vote, both revenues and education. And then as a full committee, we'll vote at 3 on Friday. That's the plan at this point. The times may change a little bit, but probably not too much. And again, thank you all for your patience today, and that we started 20 minutes late, and hopefully OIS will solve that problem so that does not happen again for us. So are there any announcements from any of the subcommittee chairs or anybody?
Yes. Okay, I'm coming.
Oh, go ahead. Delegate Smith?
Oh, sorry, my kid was banging on the door. I apologize, Madam Chair.
We all understand. Anybody else with kid, dog, cat, or any other announcements to make?
Madam Chair, just a reminder to the members of the Revenue Subcommittee, we will have a subcommittee meeting Friday immediately after the bill hearing.
After the bill hearing or after the briefing, Delegate?
After the briefing.
Briefing. Okay, just checking. Delegate Patterson just asked, how will voting be implemented? That's a few-part answer, and that's part of what some of our timing concerns. Pat in the office has to put together all the documents that she always does for us, that she hands out generally at people's desks, that she will either email to everyone's office or create a link that she'll send to everyone. That may be a slightly easier process on her end because it's a lot of work there. And then when it comes to the votes, we can do a show of hands. All 25 of us actually can fit on one screen, or because of the 25 blocks, we can all be on the screen. So maybe we can hand vote, and then people can request a voice vote at any point. And then as we do at the end of a voting session where some members check with Pat and Haley on their vote, we can leave it open for anyone to stay on the Zoom to just double check that any vote was properly taken, since you can't look at it in quite the same way. So, and again, we'll see how that goes, but hopefully we'll be able to maintain our quick pace of our famous pace for voting sessions. Any other questions? All right, see y'all tomorrow. Hope everyone